I would like to. It's the same. I would like to ask a question to Professor Attila Horvat regarding his presentation. What would you, as a scholar, suggest to the government? How to modify the regulation, and whether it is possible to put the proportional rate not to be the same for each nationality? Because if there are, I don't know, 200,000 Germans and much smaller number of Greeks, is it appropriate and acceptable to have the same proportional rate?
Okay, I fully understand your concern. Well, it's my personal opinion.
Yeah,
okay, to be honest, maybe it's a bit surprising, but frankly saying, if I were the legislator, I would abolish the whole system. To be honest, we had no special provisions for minority voting in the first 24 years after the democratic transitions. And to be honest, no one missed these provisions. And for me, unknown reasons, the government decided some 10 years ago to introduce this special preferential threshold. But as far as I know, not even the minorities missed the parliamentary representation. So it's strictly my opinion, but I don't see any serious reason to uphold this system, because I don't think that one single MP for a given minority would help the community to reach their aims. And let me remind you to the fact that the minorities in Hungary are special to a certain extent, because according to the population census, 96% of them declared their dual identity. And okay, they are Serbs and Greeks, but they are Hungarians as well. So it's the overall picture is totally different from, for example, the Hungarians in Slovakia or the Hungarians in Romania. So it would be a simple solution to abolish the whole system, but I'm pretty sure that it would be the best step from the government. But of course, you can challenge this view. Thank you very much.
I also have a question, but to Attila, because it was interesting, maybe in connection with 2018 or 2022, that as to the Roma citizens, and there was zero. Could you explain what the situation? Because, sorry.
Yes. You were very sharp-eyed. Yes. So as for the last election, it was 2022, so the last year. Maybe you have spotted that the number related to the Romani community, it was zero. The Romani were unable to set up a list because of internal conflicts, and I'm a bit embarrassed, but how to say it correctly. So, okay. Okay, so, yeah, internal conflicts maybe, and I won't explain that in a more detailed way.
If the government decides to abolish this whole system, would it have any potential symbolic impact or symbolic message for the neighboring countries, especially regarding the fact that there are many national minorities in Hungary with whom we are neighbors? So, for example, Slovakia, Serbia, we have Slovaks, Serbs, Romanians, etc. as national minorities. So would it have any message, or it's completely separate in your opinion?
As you have maybe understood that it would be not a real step back. since some maybe 11 out of the 13 minorities, as I have explained, have not even a faint chance to reach this threshold. So I wouldn't evaluate the abolishment of this minority voting system as a real step back. And it's rather a diplomatic issue, but in my opinion, the neighboring countries would not be angry with the Hungarian government if the government decide to cancel this kind of voting. And I do hope that it doesn't involve a bad message for them. Okay, and just one more sentence. For example, Slovakia belongs to the countries who has no special provisions for minorities, and I would like to emphasize that it's okay, because not even the convention and not even the other international regulations force either country to introduce some preferential voting system for minorities. So it's okay not to have a kind of preferential system, but if a government decide to introduce, then it's not all the same what kind of system they attempt to implement, because Hungary made an attempt to introduce a system, and the court said you can introduce a kind of system, but you can't, let's say, betray the minorities with a system like this.
Maybe that is the point when I have to emphasize that. However, Attila is one of our greatest researcher, but his opinion does not automatically reflect the official opinion of the Ferenc Mádl Institute. That's all. And there are some questions.
Thank you. I don't want to challenge Attila's opinion. It's just add one more information that maybe it's an unpopular opinion, but to be honest, the minorities in Hungary are practically at the end of the assimilation process. So all those rights given to them by the Act on the national minorities, including the preferential voting rights, are tools to turn back this process. So I wouldn't agree 100% to just cancel this whole system, but I also don't have a perfect answer how the parliament should manage this. Thank you.
Good afternoon. I have a question towards Professor János Pól. Yesterday you were mentioning that the level of providing evidence in criminal matters is different in Western countries than in our region. I think it can lead to huge inequalities on international level. Do you think that this should and could be somehow solved?
I'm very happy that I obtained this question today, and I can present, because Central Europe is also the part of European Union, and also there is some maybe new lines that we try to work on them in European Union. So as we know, we work on all these investigative orders issues, so there are some rules hidden behind, so we are trying to make some harmonization steps. So maybe in future the rule could approach, but from this stand I think that this is far perspective, and of course it depends on countries and the systems. I think that we can divide countries into the group of countries follow inquisitorial rule of evidence taking, and in those countries there is no option for validity sanction during procedure, like in some other countries, like for example Italy, where there is a mixed procedure with somehow option for validation of evidence during trial. So, of course, we must take many features into consideration, but saying generally about the future, how we can improve the standards and try to build the unanimous standards. So I see one obstacle, that we must try to perceive the Central European countries and Western countries based on the same assumption of being protective toward individuals. So this must be the first assumption taken. And the second one, that we must maybe try to rebuild a mutual trust among those states, as these two I perceive as the main obstacles to build this common perspective. As if on the one hand we can observe the example of Germany with a very high, with not very high level of guarantee, but very high level of trust into criminal justice enforcement authority, and also this belief in the state and toward Germany by the Strasbourg court, as we could observe, there were just 50% of cases against the states. So this is a leading state under the jurisdiction of Strasbourg Tribunal. So in opposite, we have the states as Hungary or Poland, when we have 97% cases against the states admitted. So the level of perception for the protection of human rights is much higher in the western part of Europe. So I think that if there is, speaking about detail, if there is a breach of fundamental rule in Western states, it is observed as a singular fact in the procedure. So the court is very careful to see the line between this infringement and the final decision. And when it comes to this central part of Europe, it is sometimes more direct effect on the final decision. And also, if I may add my voice, because this professor unfortunately left, but we discussed about fair trial guarantees, Article 6, and there also we could find those impacts, how the Eastern part and Central European countries are perceived when it comes to the breach of Article 6. And just one word, that when we discuss about the standard of trial, the standard is much higher for the Central and Eastern Europe than for Western Europe. So from this angle, from Article 6, I see that we are much farther than from the perspective of Article 3. Thank you.
Yeah, so I've got one question. Maybe it's more like collectively to the scholars that are dealing with the human trafficking. It's a short question. What do you think about the ideas, for example, concerning surrogacy, to legalize surrogacy, and how it's going to impact the whole incident of the human trafficking? Like, it's only a question about your opinion. For example, yes, to you, Professor Rao, because I know that you are dealing with the human trafficking, and there were some other scholars, so if they are interested.
Thank you very much for this question. Unfortunately, I don't have prepared answer for this question because I haven't elaborated this issue. However, I guess it's a good insight which I can consider in the paper after conference. And thank you for this clue, because I have to do extra research to answer this question. Some aspects of human trafficking, like the sex workers, is a very tough question, because in countries like the Netherlands, there is legalized, and in that other countries, like in the Western, like in Spain, is a very dubious question, and in our countries is not so popular because we are the transit countries. So I would say legalizing those issue might be a serious problem in the terms of the illegal immigration to European Union, and also it would be a very difficult to measure it, because under the legal would be also a dark sphere, dark scope of this procedure, and maybe some of the even legal workers would arrive to Europe legally, but behind the scene would be even the bigger number of illegal workers.
I found really interesting that definition of national minority from the law on election. So again, I would like to ask something, Attila, always him, because this temporal determination that the members of that nation live for 100 years, for 1 century, on the territory of Hungary. I suppose that that definition is connected to the application of that electoral law. So if that measure will be abolished, also that definition will not be applicable anymore. So maybe my question will not be practical in future and not used anymore. But it came to my mind, for example, me, who came in Hungary as a PhD student, and if I in the future decide to stay, and if I get the Hungarian citizenship, and if I am able to vote, and let's suppose that this provision will continue to apply, would I be considered as a member of a historical minority? Albeit my family did not live in Hungary for 100 years, but I'm like the first generation living here. So am I on the same level as families who live here for hundreds of years?
Please don't forget that this was only one element of the definition. This definition has as many as five different elements, and you have to understand in a conjunctive way. So 100 years or a century, it would be not enough to ask for a minority declaration. But where are you from? May I ask that?
From Serbia.
Serbia. Okay, but then yes, but then we have Serbian minority established by the law. So
I thought that Serbian minority were living for centuries.
yeah, I see.
Here living for 20 years.
Okay, yeah, okay.
So it is somehow for me.
Of course, then you are a member of the Serbian community. So the century provision, this element of the provision, this element of the definition, maybe connected to the whole community, not for a single person. So it doesn't matter that you came from another country 2 years ago, let me say. So it doesn't count in this matter. So there are no difference between you and other members of the Hungarian Serb community. Yeah, of course. Yeah, yes.
Sorry, by the way, we have in Poland there is also a very similar provision in the Act on National and Ethnic Minorities. In order for a minority to be a officially recognized minority in Poland, such minority needs to live on the territory of Poland for at least 100 years. And that criterion, it refers not to an individual person, but to the community itself. And basically, its purpose is to somehow limit the protection granted to national minorities with the exclusion of the so-called new minorities, who just recently have arrived to the country.
Thank you. I would add that in Czech Republic there is per definition Polish people are considered to be minority, but only in certain regions. But I would ask something else, because we have, for example, Philippine workers, prostitution and other problems. But I'm curious about the rights of minorities. As entitled member of minority, am I authorized to be instructed about occupational safety in my language in Hungary on the cost of the employer? What is official language for occupational safety? What is official language for wage policy?
To be honest, this area with minority rights is not primarily my field of interest, but yeah, we have some special provision on the use of languages, but it's interrelated with the rate of the population in a given settlement. So if, as far as I know, if but you can help me. Okay, so if the population of a given minority exceeds 20%, then this language become an official language in that settlement or in that city or village, municipality. And you are entitled to use this language, for example, in the county, or in the village office, or in the city office, or in other authorities. And for example, the title of the name of the streets and the authorities must be translated into this language as well. We have several municipalities in Hungary which are kind of double language municipalities.
Yes, just some additions, like you know, the minorities have individual rights and group rights and here in Hungary, but as I mentioned, they are more or less assimilated, so they don't have problems with the language. Just adding more information that all of our procedural codexes give the rights to the minorities to use their own language, which they naturally don't use. And also they have the right to establish minority self-government, and they can make a decision to have next to the Hungarian as an official language their own minority language. So they can make decisions and so on their own minority language, and as I mentioned, that in all the processes they can use their minority rights. So they have the right to get papers translated and so on. But this means that the procedure will be much more lengthy, so they don't use this right.
Yeah, because I'm speaking about these criminal procedures. Under Czech law, they are entitled to have interpreter in their own language. But for example, speaking about this prostitution from Thailand, there is certain kin, I don't know, Togo, Kogo, whatever, and we don't have even one licensed interpreter for this. And they get interpreters from Czech to English, but you know, Article 6 and so on.
I have one question for Dr. Katarina. When you mention constitutional complaint, is it really efficiently remedied? I ask because when we have a situation when the Constitutional Court quashed the judgment and returned to retrial to Supreme Court, and Supreme Court again says no, maybe in that situation it's better go directly to the European Court for Human Rights and skip the constitutional complaint. What do you think about it? It could be better for West time and something like that.
So, thank you for that question. In fact, it has happened. Both in Polish cases and in Hungarian cases, applicants tried to seize the Strasbourg court without, first of all, using the constitutional complaint. So the Strasbourg court, while examining if the admissibility criteria are met, had also to elaborate upon the constitutional complaint, whether it is capable of providing redress that is needed under Article 13. And well, so this is a long story, but what I meant to show in my presentation briefly, that there were cases in which generally the Hungarian constitutional complaint in its different forms, I must say that I'm very much ashamed because I'm not a constitutional lawyer, Hungarian constitutional lawyer, so I'm looking at two Hungarian constitutional lawyers and feeling ashamed. But so there were cases in which the constitutional complaint in Hungary was considered by the Strasbourg Court as an efficient remedy. But there also was one case in which the constitutional complaint was not considered efficient, so or effective remedy. I think it always depends on the circumstances of the case.
No, it depends, but you're right that from time to time, really, the Supreme Court can decide against the rules of the Constitutional Tribunal. We had such a situation also in practice, but in fact, I think it's a more theoretical than practical problem. So if you have to just exclude this, all these measures you have, so it's the obligation just to use also the constitutional system. But it's right, it is a problem, it's right, but we cannot resolve it so say it's better or worse, so it's up to case, really.